The Commonwealth Court went on then to interpret Section 301F of the law dealing with the employer's the employer's ability to rebut the presumption. The statute says that the employer may rebut the presumption with substantial and competent evidence that the firefighter's cancer is not caused by the occupation of firefighting. The appeal board, me, countless judges, and really well-established precedent have always viewed the employer's burden when rebutting a presumption to require evidence specific to that firefighter or that claimant. In the Sladek case, the Commonwealth Court said that general causation or epidemiologic evidence is sufficient to rebut a legislatively created presumption of causation. And that I think is, for people who do occupational disease work and maybe even drift into injury work, could be significant. If an employer can defend itself by bringing in evidence that in a particular population an injury is decreased, and that's competent evidence, I think that that's a complete divergence from the way the law has set previous to this. I had a case, a Supreme Court case, Joseph Kriebel versus the City of Philadelphia, dealing with hepatitis C, where the Supreme Court weighed in and said that there was specific and substantial and competent evidence needed to rebut a presumption of causation. And in a leading Commonwealth Court case that many of us cite is the Message case. It's Jeanette District Memorial School District versus Message. It's a hepatitis C case where the Commonwealth Court specifically said that you cannot rebut a legislatively created presumption of causation unless you bring evidence of another cause for that firefighter, which actually makes sense when you think about it, because if we go through all of the criteria to get the legislature to say this disease is presumed work-related, you've gone through it. The firefighter has the cancer, years of service, exposure, clean physicals. That cancer is related to his fire service. And the defendant now, according to the Commonwealth Court, can show up and say, well, wait a minute, I know the legislature said that that's causally related to firefighting, but here are 4 epidemiologic studies about the population of firefighters, and cancer's not increased. This particular cancer, whatever it is, say malignant melanoma, is not particularly increased in firefighters sufficiently to warrant that presumption. So it's, in essence, they're arguing against the presumption. I think the Supreme Court is going to have a problem with that. I know from the testimony of the city's expert is a Dr. T. Guidotti, which many of the judges have had the joy of reading some of the deposition transcripts we've taken from him. He is a noted expert in cancer in the fire service, but he's an expert that in these cases was only brought to offer a general causation opinion. And when you look at his testimony, he does a very good job of explaining what a general causation opinion is and how it's different than specific causation. A general causation opinion is based off of epidemiologic studies that are routinely, all the peer-reviewed studies, are done to a 95% confidence interval. So that means before they can say X causes Y, the study has to show an increase and be 95% certain of that increase. Dr. Guidotti's explained that general causation and scientific certainty are a significantly higher standard than preponderance of evidence, which we deal with in any type of civil action, and in particular a workers' compensation case. He's explained it as preponderance of the evidence would be here, beyond a reasonable doubt would be here, scientific certainty is above that. So if the Supreme Court allows a defendant to come in and say, look, there's no epidemiologic evidence that malignant melanoma is caused by the fire service, they're essentially saying we can't prove at a burden that exceeds beyond a reasonable doubt that firefighting alone causes this disease, and somehow that's supposed to be a definitive defense to a legislatively created presumption. So while I think it's good news, that standard would be good news for employers' counsel that defend occupational disease cases, I think it is complicating news for a claimant's counsel. And what it does at the end of the day, if that part of this decision holds up, it makes every occupational disease case from here forward an omnibus provision case. Because the only way then I can win is I have to show up with an epidemiologist and we have to bang out whether or not the epidemiology supports the claim. So sort of stay tuned to the Supreme Court's decision in the Scott Sladek matter, because it really will define many of the other cases almost every one of the other cases has the Sladek issue as one of the issues that's presented.